So today we're going to be talking about a very important topic with regard to the role of marriage and family therapists in divorce proceedings, child custody evaluations, and in how to handle receiving a subpoena. Now, the first thing that we're going to talk about is divorce proceedings. Now, with most states, the state of Georgia does have specific procedural guidelines for the divorce process. One of the first things that you want to keep in mind as a marriage and family therapist is what are the applicable laws in the state in which you reside and practice. And so in the state of Georgia, a legal divorce enables two things. One is a severance of the marriage relationship. Two is a division of assets and debts. In the state of Georgia, residency plays a role in divorce proceedings. One must be a legal resident of the state for at least 6 months prior to filing. Those who meet residency criteria can file in the Superior Court of the county in which they reside, while those who do not must file in the county where the spouse resides. The simplest divorce procedure is the uncontested divorce. So by noting that it's the simplest divorce procedure, we already realize that there are other procedures that are not so simple, but we'll talk about the uncontested divorce first. In this case, both parties would have agreed on all issues, would have prepared a petition for divorce, including a marital settlement that outlines how assets and child care will be divided. After a court hearing, a final judgment and decree of divorce are issued. Another procedure is the no-fault divorce. How this differs from the uncontested divorce is that in this case, a petition for divorce is going to include the statement that the marriage of the parties is irretrievably broken. In this case, the final judgment and decree of divorce cannot be issued until at least 30 days after the partner has been served with the petition for divorce. A third procedure would be a fault-based divorce. Now, this is the most rarely used procedure. A reason being, for a fault-based divorce proceeding, one must provide submission of proof to the courts. Now, there are some examples of fault-based grounds for divorce, and these can include, but aren't limited to, force or fraud in obtaining the marriage, adultery, desertion, habitual intoxication or addiction, and a cruel treatment that is threatening to life, limb, or health. Something to note is that in the state of Georgia, there's no legislation as it regards division of property, and therefore it's left to the judge and jury to determine that. Now, other things that are specifically involved in divorce proceedings include things like alimony. Now, of course, according to the state of Georgia, alimony may be rewarded according to three things. 1, the needs of the partner seeking alimony. 2, the other partner's ability to pay. And 3, any evidence of conduct of each party toward the other. And so, one of the things to note in the state of Georgia is that if the person seeking alimony committed adultery or deserted the other partner, alimony will be prohibited. Important for you and your clients to know. In the case of child custody, only the judge determines custody. One of the things in the state of Georgia that's going to be required by the courts and by the judge to determine custody is going to be a parenting plan. Now, that parenting plan includes a couple of things. The first thing are the specifics of physical care. Where is the care going to be taking place? When is the care going to be taking place? The second thing, transportation for child exchanges. Where will that be happening? What days? Who will do pickups, etc.? A part of the parenting plan also includes assigning decision-making authority to one parent, which is interesting because parents who do have physical custody are expected to make day-to-day and emergency decisions. Another part of the parenting plan includes both parents having access to all the child's records. And in the state of Georgia, interestingly enough, children over 14 have the right to decide which parent to live with. And the courts will consider the desires of children between the ages of 11 to 14. Now, as we're moving forward, another important element to note in terms of the parenting plan and in terms of child custody is that the court is going to consider any recommendation that is made by a court-appointed custody evaluator. And so the question becomes, who can be a child custody evaluator? Now, mental health professionals whose credentials are accepted by the court and are not excluded by state licensing agencies and professional associations may be child custody evaluators. So what this currently includes are psychologists, psychiatrists, social workers, marriage and family therapists, marriage and family counselors, professional counselors, and certified mental health professionals. So now that we've been identified as potential child custody evaluators, it's important for us to know as marriage and family therapists what our code of ethics are as it relates to this. So the American Marriage and Family Therapy Association Standard 7 of the Code of Ethics speaks specifically to acceptable practice standards for professional evaluations. Section 7.7 specifically discusses separation of custody evaluations from therapy and other forms of service. What it says specifically is, marriage and family therapists avoid conflict of interest in treating minors or adults involved in custody visitation actions by not performing evaluations for custody, residence, or visitation of the minor. Marriage and family therapists who treat minors may provide the court or mental health professional performing the evaluation with information about the minor from the marriage and family therapist perspective as a treating marriage and family therapist, so long as the marriage and family therapist obtains appropriate consents to release information. So the division of treatment from evaluative services is made distinct, with the expectation being that dual roles are avoided at all times. What this means is that as a practicing marriage and family therapist, if I already have somebody who is being treated by me, I cannot in the middle of that switch to being the MFT that is conducting a child custody evaluation. That is a dual role. So roles are going to be clearly defined for either service at the beginning of the relationship. If this is a treatment relationship, then that role is going to be defined and adhered to. If this is a child custody role, child custody evaluation role, then that will be clearly defined at the beginning of services. Now, why is this important? This is important because, especially for evaluations, there are going to be differences in confidentiality requirements due to the legal nature of the proceeding and the requirements of the court. So let's talk about what all is involved in a child custody evaluation and why it's so important to differentiate those roles. So according to the APA, the American Psychological Association, custody evaluations are going to include a number of things. First of all, there has to be clarification of the referral question. What this means is that there's specific information that the court is looking for in terms of evaluating whether or not a child should be placed with one parent versus the other. It's going to be important for us as MFTs to be able to know exactly what that referral question is, what are the parameters needed by the court, what are the requirements that the court is looking for. And that will help determine whether or not we are able to provide that information and whether we're able to do so in a timely fashion. The second APA guideline as it relates to custody evaluations is informed consent. Now, informed consent, of course, is going to include all the potential uses of the data that's being gathered. Who is it going to be released to? Who all will be involved in the evaluation? And this informed consent is not just spoken word. It is a written consent, written in the language that the client can understand. Another guideline from the APA is that child custody evaluations are going to include multiple methods of data gathering. This can include psychological testing. Now, if it includes psychological testing, this may be an area in which the MFT may think about referring out for psychological testing to be done, testing and interpretation. The other parts of data gathering may include clinical interviews and behavioral observations. They may also include access to documentation from schools, healthcare providers, childcare providers, extended family, friends, acquaintances, and other collateral sources. So you're beginning to see why it's so important to have that informed consent in the very beginning, outlining exactly what is going to be happening in this process. And you can also see how this differs a lot from therapy. Another guideline from the APA is to interpret the data in a manner that's consistent with the context of evaluation. And what this means in layman's terms is that recognizing that people being evaluated are going to react a little bit differently than people who are not involved in an evaluation, and realizing that the process of testing can adversely affect participant reactions. Another thing that's important for the MFT conducting a child custody evaluation to take note of is ensuring that you have documented evidence of every attempt to collect your data. Now, you may find that the court gives a specific time period, and in that time period, maybe you've tried to reach a certain number of people, a certain type of people, family, friends, etc., and you're having trouble not getting the information that you need. It's going to be important for you to document all of those attempts to make contact. And you're also going to give the rationale for why it was important that this person or this data be included as part of your evaluation, and you want to submit that to the courts. Your recommendations at the end of your evaluation is going to be based on the best interest of the minor child. And of course, all your records, make sure those are maintained in accordance with ethical and legal standards. So now, we've gone through child custody evaluations, sort of looked at the guidelines for that. We've looked at the AAMFT guidelines in terms of our ethical obligations, and we've looked at the divorce proceedings. So we've been subpoenaed now. And what a subpoena is a legal document coming from the courts that requires therapists to appear in court to testify and or to provide legal documentation. So there are a couple of ways to prepare yourself for that sort of interaction. And these are just a couple guidelines on how to deal with subpoenas when you get them. So the first thing that you have to ensure is that any documentation, any subpoena, anything that is received includes a release of information from your client that authorizes you to provide that documentation. If you don't have a release of information from the client stating that it's okay for you to share information with these outside parties, then you want to start by checking with your client and not the legal representative. Having checked that out, definitely respond promptly, not to give over information, but rather respond to, at the very least, indicate that you have received this subpoena. You want to evaluate the request after that, obtain legal counsel if necessary, and before responding, consider the subpoena source, the client's welfare, state and federal laws, and of course, your code of ethics as it surrounds that documentation. Provide minimum information necessary. When you are responding to the subpoena, this may be in the form of a summary of treatment versus the entire treatment file. Of course, this is going to differ based on the specific requirements of the subpoena. What you do not want to include in documentation submitted to a subpoena are any psychotherapy notes. It's actually a recommendation that therapists do not keep psychotherapy notes because there are no records that are immune from disclosure. And so HIPAA suggests or makes the requirement of minimum necessary in terms of documentation. So that's always a good way to go. So I hope this was helpful information. We've again talked about divorce proceedings according to the state of Georgia. We have talked about child custody evaluations and guidelines for conducting same. We've talked about ethical considerations for the marriage and family therapist as a child custody evaluator. And we've also looked at guidelines for responding to subpoenas. Information with regard to all of this can be found from the APA, can be found in the AAA MFT, can also be found in a Zora 2016 article called Subpoenas and How to Handle Them, Guidelines for Psychotherapists and Counselors, and that was published in 2016. Thank you.